Hi, everyone. Thank you for joining today's webinar. My name is Gabriela Urizar, and I'm an immigration attorney at Manifest Law with almost a decade of experience. And we're going to be answering some of the questions that were previously provided and also open the floor for more questions in terms of work visas, what's going on right now with visa appointments, also different pathways to explore as an immigrant if you want to live and work in the US. So let's see, let's start with the first one. Okay. So we have a question here. My question is about the change of address for a pending petition. I filed my I-140 for an EB-2 NIW. However, I moved. I have tried the online tool. It's not working. Should I file the AR-11 form? Yes, so it is actually a legal requirement on their immigration law that every non-citizen, including green card holders, file a change of address within 10 days of moving. So it is very important that you submit a change of address. If you're trying to do it through the website and it's not working, try to document that, take a screenshot. It will also be helpful to try to call USCIS and speak to a USCIS officer. And as a last resort, you can also file the form. But it's very important that you file within 10 days of moving. Okay, let's take another question. Great. This is a great question because thankfully with the NIW, you really do have the ability to provide information on how your contributions help the US, especially in the medical field. We do know that there is a shortage of professionals, both dental professionals and medical professionals in the United States. So you do have a strong profile. And also as an orthodontist, you do have the degree that is required as well. In terms of how you can craft your argument, as you know, the first requirement is that you have to show that you are going to advance an endeavor that's going to be of the national interest of the US. And I think this is one of the most important ones. And in terms of how can you prove this or organize this? If you are working currently in an area that has a shortage of orthodontists, you can provide a combination of research showing this lack or this need of orthodontists in this area, and also tie it together to the work that you have been doing and the contributions that you have been doing. Officers love metrics. So if there is any way that you can provide charts, if you can show with numbers the amount of patients that you see, why dental care is so important for the interest of the US. And then for the second prong, you have to show that you are well positioned to advance this prong, right? So this is the section where you make the connection to you, to the work, to the contributions that you have given to the United States. And this is the area as well where you will be providing letters of recommendations from experts in the industry that can attest to your contributions. In terms of selecting the letters, I say it's better to do 5 to 6 very strong recommendation letters than 10 or 15 generic ones, right? Now, in terms of what USCIS is looking for when they're reviewing the letters, they tend to place more credibility on letters for people that are independent sources rather than, let's say, a coworker or your direct manager or prior employers. So if you can start thinking about a diverse pool of recommenders like professors or people who work in research organizations that talk about, the impact of dental health, especially in underserved communities, people who are familiar with your work, that have quoted your work, if you have any publications, if they have used your work to advance any other type of research. So all of these will go in the second prong, where you provide how you're directly impacting the United States. And then the third and last prong is that you have to argue that it is in the U.S. best interest to skip the labor certification perm process, which could take about 2 years for you, instead of that, applying without the perm labor certification. And for this one, you have to think about timing, right? So if you're able to provide a combination of the timing of why it's so important for you to be able to stay in the US rather than wait 2 years until your labor certification gets approved. Talk about the critical need of dental health, especially in the areas where you're working. Also, this administration cares a lot about financial competitiveness. So if you can make a combination of showing what other countries are doing, right? Like in terms of dental health, like how much, the advances that they're doing are saving, how much money they're saving the government. And then you can talk about your situation and how the work that you're implementing, any type of research, any type of work, how that's saving money for health insurances or the government. So if you can do an overall approach of keeping in mind what this administration cares about with the underserved communities, and the huge shortage of orthodontists, you would be in a good position. Can we take another question? Okay, great. So we have a question here that was previously submitted, and it reads, if I have been on an H-1B for almost 7 years, applied under EB-2 and recently lost my job, what are my options? Specifically, if I leave the US and return using my valid H-1B visa stamp, which is valid until February 2026, will switching to a new employer trigger any of the new rules? Okay, so the guidance that we have from the government of when the $100,000 fee kicks in is when the petition is filed after the date that they provided, which I believe is September 21st, and for someone that was abroad and also didn't have a valid visa stamp, right? So, or if USCIS determines that the case it's approved for consular notification. So in your situation, if you do have the 60-day grace period after the ending of your employment, so the best approach will be to find another employer, have that employer file an amendment, a change of employer with an extension, so that you're able to stay in the US and you are able to continue working with that H-1B. Now, in terms of the approved I-140 that you do have, if the I-140 was filed more than 180 days, 6 months, then you're able to port that I-140 to the new employer, and you can continue extending your H-1B past that 6-year limit, right? If you are not able to find a new employer before your 60-day grace period expire, then you also do have the option of exploring other self-petitioning petitions. For example, I'm not sure if the EB-2 that you have is an NIW or if, but there is also the EB-1. If you're able to prove that you meet at least 3 of the requirements that are posted for the extraordinary ability, that you're at the top of your field, that you're a trusted expert, that is another option that you have to self-petition and file for a new I-140 under the EB-1 category. And the good thing about this is that, of course, you no longer rely on an employer. You can work for yourself. You can work for anyone else. But also you can request for the earlier I-140 priority date to be used instead of the one for the new petition. Now, let's say you don't want to file a new petition, you don't want to self-sponsor, and you want to rather do a B2 after your 60 days expire. So if you can technically file a change of status from H-1B to a tourist or another type of temporary visa. You just have to keep in mind that you have to have an aligned intent. So when you file the application, to be sure that you explain that you need the extra time to wrap your affairs, to close the rental or the home where you're living, to take out your children from school. If you're able to find another employer that wants to file an amendment to reactivate the H-1B that you had, this one will likely require consular notification and will likely be subject to the $100,000 fee, because once you are on B status, if someone files a change of status back again to the H-1B, it is very unlikely that an officer will allow for the change of status here in the US. They might want you to go abroad and activate it. It could happen, and it has happened, where in this situation, officers issue the change of status and people are able to move from a B visa to an H-1B without having to leave the country. in that situation, since you're inside the US and you already have a visa stamp that's valid, you wouldn't need to depart, and the $100,000 fee wouldn't apply in this situation. And also keep in mind that since you already have a visa stamp for an H-1B on your passport, let's say if an employer you're able to find a new employer and they're able to file a change of employer here in the US, you don't need a new visa stamp, right? Because you already have the H-1B. Even though that H-1B belonged to another employer, you can still continue to use that H-1B until it expires or until the new status expires. Okay. How will the latest announcement on LinkedIn verification work for H-1B renewals? On what basis can the H-1B renewal be denied based on a LinkedIn profile? So I'm assuming that you're referring to the recent guidance that the government issued in terms of subjecting H-1B holders and H-4 holders to further scrutiny for their social media. So attorneys don't have a very clear guidance on specifically the examples that the government will be looking at. We do understand, especially from the guidance that the government has provided, the very minimal guidance, that for anyone who is applying for a new visa stamp, either for H-1B or H-4, you will be required to leave all of your social media public, and they will do an assessment of all the social media to be sure that nothing that you have posted conflicts with the government or could pose a threat to national security. And again, we don't know what this means. We haven't seen a denial for someone based on these requirements. So I would continue monitoring the news and I will continue monitoring the information. But yes, LinkedIn is also a platform that will be reviewed if you're applying for an H-1B visa. The next question is, does one have to make social media profile public just before the H-1B renewal or keep it public all the time? So the guidance that the government provided indicates that the further scrutiny of social media applies for people who are seeking a visa stamp. They haven't really applied this for people who are applying for an extension or an amendment inside the US with USCIS. However, if you are applying for a work visa, especially an H-1B, the recommendation to be safe is to keep your profiles public, to do an audit of all the social media you have, and be conservative in the type of in how much information you share on your platform. Let's see the next question. I am currently an undergraduate student pursuing a major in computer science. What steps should I take in the right direction for fulfillment of criteria of the O-1? Oh, this is a great question, and I love to answer this question because I feel like students don't really know about the O-1 or about self-sponsoring for a green card through the EB-1, and rather they rely solely on the H-1B, which is a great visa, but again, it's lottery-based. But with the O-1 or with the EB-1 extraordinary ability, students do have a lot of agency. There's a lot of things that they can do, especially if you are doing a degree in STEM. So in this situation, a student that is currently pursuing a degree in computer science, I will say, try to think of a more narrow area where you want to start putting in the work to excel and to have a lot of recognition. And look, do research. What do you like? What is something that's very trendy right now? Like, I know that AI is something very trendy, right? So even narrow it further. So to give you an example with AI, like perhaps you can look about in an area where AI is not really being utilized and take advantage of that and become an expert, right? Like create a blog, start talking about it every day, create a podcast, start hosting people in your podcast like experts in AI. You can also submit your profile to different podcasts that are talking about this type of narrow area and position yourself as an expert, right? Like go talk about it, go talk about what you learn, start working on perhaps publishing materials, right, that could be used and cited by other professionals. Build a Google Scholar profile, and then start checking where people are currently citing you from. All of that, start after you start building that reputation, those materials, like start submitting your work for consideration of awards, even if they're just local awards, right? Like start reaching out to these organizations that provide awards, start looking into organizations that require you to apply and are very competitive in terms of membership, apply to be a part of them. Also, fellowships are considered as awards because you have to apply and you have to compete with other people. So just keep this in mind if you're thinking of applying for a fellowship or a scholarship based on merit and your grades. These are great examples of you being at the top of your field. Another way that you can start working towards building your profile is, seeking recognition, right? Reach out to nonprofits that are talking about the topic that you're trying to position yourself. Do networking. Start networking with professors. Start networking with industry leaders, with CEOs, with people who are at the top of their field, because in the future, when you are ready to go forth and apply for an O-1, you will need 5 to 6 recommendation letters from industry experts. So it would be great to have a variety and a diverse group of people who are recommending you. So those are my recommendations. And it also, if you start being proactive and start building a profile right now, you're more likely for an sponsor, an employer, an agent to sponsor you, right? Because they will know that the money that they're going to invest in filing the O-1 is going to be worth it, rather than if someone else comes and they're totally unprepared, they haven't built a reputation, they haven't built a credibility, it is less likely that an employer will sponsor you. And just remember, O-1s do need an sponsor, either an employer or an agent, to be able to request you. Okay, let's take a look at the next one. Can one file an H-1B amendment, an extension based upon a minor salary annual increase more than 6 months ago before the H-1B renewal date? So this is a great question as well, a question that comes up a lot. H-1B amendments are only required if there is a material change in the position. So for example, a salary, especially if it's a minor salary increase, it's expected for a professional, especially in a professional occupation, to have salary increases. So likely not, you don't really need to file an amendment. If there is a material change, like for example, you're going to be working from home and you just move to another address that's out of the MSA area, then that would be a material change. Or if you change roles completely and the type of duties that you're doing are 51% or more different than the initial petition, that would be a material change. So just keep in mind that a minor salary increase wouldn't likely require an amendment. So it would be best to wait until you're ready to file for the extension and then provide that information. The next question we have here: what will be a good time to go for the first time H-1B stamping next year, given all the uncertainties? H-1B renewal in September 2026. Great. So as we know, there have been a lot of rescheduling and cancellation of visa appointments for H-1B holders, especially right now in December, because of the new announcement of the administration of increasing the scrutiny and the vetting of people who are applying for visa stamping. So officers, of course, don't have the capacity to do this depth of review with all the appointments that they had, so that they started moving all the appointments to, we have clients that have appointments moved to April, May, even up to July. So it is my understanding that it's going to be a little bit tougher to get an appointment for the first half of next year, especially in countries of a large demand of H-1B, like India. So if you're from India, keep in mind these numbers and try maybe to schedule an appointment, especially if it's not urgent, towards the middle or second half or next year. Of course, keep monitoring the news and keep monitoring the availability of visa stamping, because things are moving, things are changing, things are very fluid right now. So it is important that you stay on top of it. But if you don't have urgency or you don't anticipate traveling out of the US, the recommendation will be to wait until next year, mid-year, or the second half of the year. What is the typical processing time you're observing for NIWs, standard petitions, non-processing? So this is very important for people to know that you're able to go to USCIS website and look up USCIS processing time. And then for the first selection, you will be choosing the I-140, which is the form that you're looking for in terms of processing times. And then for the second selection, you will click the National Interest Waiver, or EB-2. And then you will get a response on the processing times. But I actually did look them up right before the webinar. So it looks like USCIS is taking up to 20 months to issue a decision on an I-140 based on the National Interest Waiver. And we have to remember that a decision means a request for evidence, a denial, or an approval. Very, very unlikely that USCIS will issue a denial without first issuing a request for evidence and providing the foreign national the opportunity to provide a response, but it happens, right? So think about in terms of, like, for example, if you are on an H-1B right now, and you might max out and you need that I-140 approved so that you're able to extend that H-1B past the 6-year max allowed time. Think in terms of a strategy, what helps you, right? Like, do you need an approval right now? Do you have the ability to wait up to 20 months to hear from USCIS? Or is it better to file the premium processing now, have a response? Even if it's a request for evidence, you'd rather have it now than in 20 months. But it's taking up to 20 months on the regular processing. My situation is that I am on a B2 change of status pending after a job loss. It's been 2 months since the petition has been pending. Do I need to wait to apply for the H-1B again? So this is a strategy that a lot of people go through, especially people on an H-1B when they get terminated and they run out of the 60-day max out time. They usually file for a change of status so that they're able to stay in the country, wrap up their affairs, or like look for another job. USCIS does take a long, long time for adjudicating change of status petitions to B2. So just to keep that in mind, in terms of applying for an H-1B again, technically you can apply for an H-1B. You're able to do that, apply for an H-1B change of status to move back, especially if you just found a new employer. However, keep in mind that USCIS might issue the approval for consular notification for you to have to depart and activate the H-1B abroad, or they might need for the B2 to be approved before issuing the change of status. Also keep in mind that the last action prevails. So for example, if you're able to file the H-1B for the new employer, and let's say it gets approved, be sure to withdraw the B2, because if the B2 gets approved after your H-1B approval, the B2 approval will prevail and you will be moved back to B status. So just in terms of a strategy, be able to plan that out. But technically, yes, you could apply for an H-1B change of status, but it depends on what USCIS will determine when adjudicating the petition. For an EB-1A O-1, what would be considered a high salary for electronics engineering in the Bay Area based upon your past experience or interactions? So it's important that you take into account, of course, the area of employment and the credentials. Like, for example, for your job right now, like what are the minimum hiring credentials that they're looking for, and what is the average salary that they're offering an electronics engineer in that area. So I will say $150,000 sounds like average, but also think about entire compensation. When you make the argument that you demand or command a high compensation, they're asking for the whole package. So if, for example, you're getting bonuses or you're getting stocks or you're getting any other benefits, you are able to argue that it is the whole compensation package rather than just $150,000 salary. But I will say for anyone that's watching that's interested in seeing how their salary or their entire compensation compares to other professionals in their area and also physical location, Look at sources like the Department of Labor. The Department of Labor does have employment handbook that you can find online where they list the average salary for people with similar credentials. So that's a very helpful source, especially when you're ready to submit your application. You can provide a copy of that as evidence that you're commanding a higher salary than people in your field command. What is a good way to contact USCIS to seek clarity on pending NIW's I-140 applications? The first thing is to keep in mind if you are already out of processing times. Like I said, you can go online and you can look up USCIS processing times, select I-140, then NIW, and see how long USCIS is taking for regular processing time. If your petition is still under the 20 months, you might not be able to reach out to USCIS. The system just won't allow you, either online or on the phone, because technically they're still within processing times. However, if your petition has been pending over 20 months and you don't have a response, now you're able to either go online and submit an inquiry with USCIS. You can go and search USCIS inquiry request, and then when they throws you to the page, you can select out of processing times and then provide information about your petition and how your petition is already out of processing times. Now, in terms of contacting USCIS, you could call USCIS. The phone number, I believe, is 800 375 8253. You can find this online. And then to be able to get through an officer, a trick that I use, for example, is that when the automated voice notification or voice that they have ask, what can they help me, how can they help me, I say lost receipt, lost receipt, lost receipt, until I'm able to go through it and they're able to connect me to a USCIS officer. Of course, when you're able to speak to a person, they will ask for the receipt number, so be sure to have it at hand. And also an I-140, if this was self-sponsor, you will be able to speak to an officer. But if this was filed by an employer or an agent, you are not able to speak to an officer because the petition belongs to the petitioner. So in this case, if your employer filed the I-140 NIW, only your employer or the attorney on record are able to speak to an officer in regards of this application. And this also applies to submitting an inquiry request through their website. Only the petitioner or the attorney of record is able to request the information. The beneficiary is not able to unless you're self-sponsoring. Let's see the next question. Do I need to go ahead and submit an updated DS-160 if I did not disclose a couple of inactive social media accounts, booked appointments before the social media vetting? So for this one, I understand. Check with the U.S. Embassy or consulate where you will be having the appointment. But I do understand that in some situations you are able to update the DS-160. If you're not able to and your appointment is coming up, you can always present this information to the consular officer that's interviewing, and of course provide the information that you had already filled out the DS-160 prior to the announcement of the vetting. Okay, we have another question right here. I am writing to inquire about the status of your firm's EB-2 processing. I am currently employed as an engineering at a technology company through a work permit. So in terms of manifest, we're going to provide a link where you can schedule a consultation so that an attorney from our firm can actually review your profile in more detail and give you a more tailored approach. In terms of processing times, it depends on the applicant's profile. For example, some applicants have very, very strong profiles and they have done the work of gathering and organizing the information. So it's easier to provide a shorter processing time. But if someone still needs a little bit of building, or for example, if one of the prongs is not as strong, attorneys do like to first work on that prior to start working on drafting and submitting the petition. How long before one can see any movement on the $100,000 fee case from the courts? asking so as to understand when should I plan to travel to my home country. H-1B renewal is up in September 2026. So in terms of what the courts, we know that a lot of large companies and even public organizations have filed lawsuits against the administration to stop or put an injunction for this $100,000 fee. We haven't received a feedback yet. The courts are still waiting to issue either a temporary decision or a permanent decision. You can follow us on our social media. When something comes up, especially with the H-1Bs, we are providing information and updates the same day. So it's very important that you keep updated, especially in terms of planning. For you, I will say be very careful in terms of a strategy. For example, if you're up for a renewal in September of 2026, file for your extension and change and extension of status here in the US as soon as you're able to, which is as early as 6 months prior to the expiration, and then keep monitoring the news, what's going on, so that when you are ready with the approval notice and are ready to extend your visa stamp, you are able to do it in a safer manner rather than with higher risk of staying stuck or having the $100,000 fee applied to your application. Okay, awesome. We have another question. Can reference letters from early stage startup CEOs stating volunteering contributions to raise funds and get projects be used to meet the O-1 EB-1 awards criteria? Startup is not employer and has no earnings. I will be very careful with this because, especially depending on the type of visa that you were using while you were volunteering, because people who are on a temporary visa, like an F1 or even an H-1B, are not really permitted to volunteer if the volunteering work usually pays other people. Like, for example, if you were raising funds, right? Usually this type of job or work pays people. There are positions for this type of work. Some of the options that people are allowed to volunteer when they're on a temporary visa are very limited, very restricted. Like, for example, volunteering at a soup kitchen, right? Like that would be a very small exception that you're able to volunteer. But now, in terms of the reference letter, CEO of a startup is a good reference if he can focus on the contributions that you have done to the field rather than to his organization. So if he's familiar with your work, if he's familiar with your publications, if he's familiar with the type of contributions that you have done to your industry, I would say have him focus on that when he's writing the letter. What judging evidence are required for the EB-1 clients? So in terms of, it totally depends on your field, but in terms of choosing to participate in judging, USCIS usually puts more emphasis and credibility on judging the work of your peers. So if you are, reviewing papers, like being a peer review member, or if you're judging competitions or any other type of conferences, keep in mind that it carries more weight and credibility if you're doing that for the work of your peers, like people in your industry, people with similar credentials as you, rather than doing it for students. For an O-1 EB-1A, what are the approval rates right now? And how will you be helping with requests for evidence or noise? I see a refund policy if the approvals are not processed through manifest law. What do you mean? So manifest law has different packages for handling this type of applications, and the premium one is the one that has refund policy, right? And we can provide you with more information that's more tailored with your case. For example, the case has to be a very strong case for the refund policy to apply. But in terms of how they will be helping, the attorney is able to not only help you with putting together the application and file it, but if you have a gap where we believe that your application is not strong yet for an approval, we can provide the guidance on how you can be proactive and close that gap so that when you're able to file for the application is very strong. In terms of request for evidence or noise, again, attorneys at Manifest are able to handle that as well. We do have attorneys that have handled hundreds, if not thousands, of O-1s and EB-1As, and from every single industry, IT, finance, even defense, public affairs. So that's the good thing about Manifest, that if you want an attorney that is tailored to your field or has gotten approvals for similar profiles, you're able to request an attorney that has that experience so that you feel more comfortable working with that type of attorney. Just 1 second. Let me see if we can provide a link of the consultation. Awesome. So we have a question here. If senior membership in this organization satisfy the EB-1 membership criteria. So if it is competitive, if you have to actually apply, not just have a degree in engineering or pay a fee, then it will satisfy the EB-1A membership criteria. And again, keep in mind that if you have evidence of, and then you're able to provide a very strong argument for other criterias, then the number of membership is not as important, right? It's an overall test. So you want to be able to have criteria that is very strong if you're just providing one or two pieces of evidence for other criteria. So it is an overall approach. But if the membership is competitive, you have to apply, then it qualifies. If the H-1B wage increase rule comes into play, will it impact existing H-1B workers at the time of the H-1B renewal next year? Will the new wage have to be forced on the LCA? So the rule hasn't passed yet, and we don't have guidance, specific guidance on how this will be implemented. But looking at past changes that have happened for type of work visas, when a new change happens, especially like this one, it will likely apply to all new petitions, either if there are extensions or amendments or just new fresh H-1B petitions. So it will likely apply, but we're going to keep monitoring the information because the rule hasn't passed yet. I am an H-4 holder and I'm planning to travel to India. Is for stamping also going to be affected with the recent cancellations? Unfortunately, yes. The guidance that the government issued recently about the scrutiny, the heightened scrutiny and the vetting for social media applies to H-1B holders and H-4 holders that are seeking a new visa stamp. So keep an eye on that in terms of booking your appointment, and please be very strategic about booking your appointment because we've seen a lot of people who have gotten stuck abroad and are not able to have their appointment until April, May, even July. So just keep that in mind. But yes, the new cancellation, rescheduling that are happening are also affecting H-4 holders because they're also subject to the social media vetting. EB-1 eligibility. Can sale of IT consulting business be qualified in commercial success category as comparable evidence? So in terms of this criteria where you have to show that you have commercial success, if you can make an argument on how your work and your accomplishments do generate an income, like for example, copies of contracts of people that are seeking your services, or the sale of an IT business as well, like if you generated profits, that could also qualify as showing that you have commercial success because your work, what you have created, is generating profits. I hold a valid B1, B2 visa. Currently, my L1 petition is under process. I have to enter the US for attending a business meeting. Can I continue with processing of the L1 in parallel or wait for returning back to the US? So in terms of the best approach and the safer approach will be to wait for the L1 to be approved and for you to enter the US under the valid L1 and also visa stamp. Technically, you could come into the US with a B1, B2 if you're able to show that you have the correct intent, if you're able to show evidence that you're coming just for a business meeting and you're not going to be compensated and you're not going to be doing significant work in the US. And people have done it, but keep in mind that CBP officers have a lot of authority and discretion, and they're not required to follow guidance from, let's say, USCIS. So it could raise some red flags if you're coming in with a B visa while you have an L1 pending. Like they could question you. They could think that you're trying to circumvent the approval or the processing time of the L1 and trying to come into the US to do work earlier. So technically you could, especially if it's urgent, but if you have the ability to wait until the L1 gets approved, I will say it is better. It is recommended to wait. If high salary and judging criteria are not applicable to my case, which of the other 6 criteria you suggest emphasizing on priority basis to strengthen the O-1 petition? So I think it depends on your field. If you go online and you look up the O-1 criteria, you're able to see the list of criteria, right? So for example, for someone that's, let's say, in the IT industry, they're able to talk about their, one of my favorite criteria is, how you have provided contributions to the field, because you can really talk about your significant accomplishments. This is the most broad criteria. You can provide letters of recommendation. You can make a lot of arguments, provide research, outside research, to show that your work has impacted the field. So this one, to me, this one is my favorite criteria, because you can really have a lot of agency to strengthen this criteria. Now, in terms of the high salary and judging, if you don't want to provide evidence on that, you can perhaps look into joining a membership that's exclusive, that it's competitive, membership that is not just given to anyone just because they have a degree and they pay a fee. So that one is a good one. Also, if you are able to show that you serve in a critical leadership role for a reputable company. So if you work for a large company, I will say try to get as involved as possible. Usually large companies have a lot of opportunities for employees to be involved. So reach out, try to be, membership in a community, offer to be a speaker when they go on conferences, really show that your role is critical to the organization. And that's also another criteria that you do have a lot of agency for and that you can do a lot of work. Also, another criteria is, if you are invited to speak at major, conferences or events, or recognized as an expert in the field, that one you also have a lot of agency. Like you can reach out to, again, podcasts, you can reach out to conferences, volunteer, serve as a chair for planning the conference, serve as a speaker, like show that you're being asked to speak on your field because you're a trusted expert. So also that one you do have a lot of membership, a lot of agency. Okay, so what are the current processing times for common visa categories like the H-1B, O-1, etc.? If I apply for a new visa and my current work permit expires before the new petition is approved, can I stay in the US and continue working? Also, aside from the F1, what other visa types allow someone to study? So the H-1B, I will say you need to first identify if you need a work permit under the current visa that you're working on, or if you are able to work incident to your status. So the H-1B, you don't need a work permit. You can work incident to your status. So for example, you're on an H-1B and you file for an extension, but then your H-1B expires and the extension is still pending. There is a rule that's discretionary. That's the 260 rule that says that as long as you don't depart the US, you can continue working and living in the US for up to 260 days, or up to when the decision is issued, whichever is shorter, right? So for example, you file for an extension, but you don't really have a month left. You're just recapturing time and you're filing for a 2-month extension. You wouldn't enjoy the 260 days because the 3 months is shorter. So whatever is shorter prevails, but you're able to keep working and stay in the US while the extension is pending. For someone on an L2 as well, you can work incident to your status. You can work as long as your I-94 record shows a validity. So keep an eye on the I-94 record. Now, for people that require a work permit, like let's say an H-4 holder or someone on OPT, unfortunately, a recent rule that just happened, I think it was in October, automatic extensions are no longer given unless you fall under the exceptions. And I believe one of the exceptions is being a TPS holder. But if you don't fall under the exceptions of the rule that was provided in October, and your application was filed after the cutoff date, which I think was at the end of October, you no longer enjoy automatic extension and you have to stop working until your new work permit gets approved. So it's very important that you speak to the immigration attorney handling your case, and being open communication with your employer, because automatic extensions are no longer valid for most of the visas. Now, going to the processing times, I looked them up, and currently for the H-1B on the regular processing, it is taking about 4 to 7 months to hear back from USCIS. Now for the O-1, it's taking between 6 to 8.5 months to hear from USCIS. For the EB-1A, which is a green card based on the I-140, is taking about 19 months to hear back from USCIS. All of these the majority of these have the ability to have a premium processing, so just keep that in mind as well. And then for the national interest waiver, I-140, it is taking up to 20 months from people to hear back from USCIS. And again, you can go online at USCIS processing times, select your type of visa, and see the processing times that USCIS is taking for adjudicating your type of visa. The next question is, I heard many new USCIS officers are judging EB-2 NIW cases with the EB-1 level scrutiny, which is lowering approvals. How should applicants prepare a strong case under these tougher standards? In terms of the NIWs, there's this misconception that they're no longer being approved, which is not true. Sure, the scrutiny is higher, but this is a direct result that the last few years, large IT companies file massive amounts of NIWs for people that didn't really qualify, like, for example, just because they were in STEM. So the government caught up to this and raised the scrutiny of the NIWs. This is why it's so important to speak to an experienced immigration attorney, because they've handled hundreds, if not thousands, of NIWs. They've seen approvals, they've seen denials, they've seen RFEs, so they know what USCIS is looking for. They know how to craft the argument, and they know how to organize it in a way that it's convincing, right? Now, how you can prepare for a strong case. Officers love metrics and numbers. So if you're able to provide evidence that shows with metrics and numbers and charts how your work is of the national interest for the government, that's very helpful. Also keep in mind that officers are not experts in your field, so try to stay away from very technical language, very disorganized, very confusing. Also keep in mind what the administration cares about. Like, for example, this administration cares a lot about being competitive with other countries, cares a lot about financial, right? The financial gains that the administration is getting from your work. So for example, I'll give you an example. I had a client that was working in renewable energy. With a past administration, the argument could be very direct, right? Like, look, his work is helping the environment. We're trying to be cleaner, renewable energy. But right now we have to be more creative because this administration cares a lot more about staying competitive and the being financially competitive as well. So in taking that into account, we drafted the argument as of, look, Sure, he's in renewable energy, but because of the type of energy that he's doing, these are the metrics of how much money he's saving the federal government, right? Like less shutdowns of energy, more access to energy to other communities, saving money, saving all of that, but also competitiveness, right? Like, look what these superpower other countries are doing in terms of renewable energy. We don't want to stay behind, right? So that's why we need this person here, because this person is advancing all of this type of technology. And also tie it back to national security, which is another, as we know, is another huge concern of this administration, right? Like, do your research. What type of energy or technologies or software is the military using, right? What type of software are the Navy using? If they're using software that's being developed, thanks to the type of work that you're doing, and even if it's not directly, like even if you're just working on a type of technology that's assisting in or becoming the building block of another technology that the military is using, that's a great example to show how you're directly impacting the benefit of the US. So national interest, being national security, being competitive with other countries, and also the financial gains. My priority date, EB-2, as per the date of filing, is current by final action, but final action date is still 5 months behind. My I-140 is approved. Should I file for the I-485 now or wait? So this is a misconception that a lot of people have, especially because the visa bulletin can be confusing. So when you see the visa bulletin, when the Department of State issues the visa bulletin every month, they issue the family-based categories and the employment-based. Since you're asking about I-140, I want you to pay attention to the employment-based. The employment-based categories have two sections: final action date and date of filing. Final action date says the date, the priority date that they're taking for them to approve your green card, that there is availability of enough green cards for them to approve your green card based on your priority date. Usually this final action dates chart is used by people who are processing their green cards through consular notification, right? Like if you're abroad, like you don't have to be physically present in the US for your I-140 to be approved, right? Like you can be abroad and an employer here can be doing the whole processing. So if you're abroad and you're waiting for your priority date, you have to look at the final action dates. However, if you are physically in the US with valid non-immigrant status, and every month when the Department of State issues the visa bulletin, USCIS will post on their website what section they're honoring. Most of the time, they will say, we're honoring dates of filing, which means you can go ahead and apply for your adjustment of status. If your priority date is currently current on the visa bulletin under dates of filing, I will recommend you file as soon as possible, because the priority dates can always retrogress next month and you won't be able to apply. The benefits of applying for the I-485 as soon as possible is that even if you run out of status and if you max out, your status is pending adjustment of status. So you're likely protected, right? Like you have a pending status, so you're likely protected and allowed to be in the US. You're also allowed to file for a work permit when you file that green card application. So you can include in the package your I-485, your I-765, which is the work permit, and then the travel document, which is the I-131. If your current non-immigrant status expires, you can always rely on that work permit based on the pending adjustment of status application, so that you don't have a gap in employment. So yes, if your priority date is current under dates of filing and you're physically in the US under current non-immigrant status, you're able to apply as soon as possible. We have a question here about what is the current time frame for receiving a green card under the EB-1A category. So I think this will depend on when your priority date is current. Again, keep monitoring the visa bulletin. If you file for the I-140 under the EB-1A and your priority date is current, like if it shows a C under the country that you were born, then you're able to do a concurrent filing and file for the I-140 together with the green card application, which is the I-485. It is taking about 2 to 3 years to get a green card. if you file under payment processing, this doesn't affect directly the I-485, just the I-140, the first part. But keep in mind, USCIS cannot adjudicate your green card application if the I-140 is not approved. So if you're able to file for payment processing and secure that I-140 approval, then the process will inherently move faster because your I-140 is approved. So USCIS is able to make a decision on your green card. EB-1A, how many publishing articles about me are required to pass the publishing category? So in terms of the amount, I think it will depend as well on the field that you're in and how strong your other criteria is. If you're really using the publishing articles about you as one of your strongest criteria, I will say 8 to 10 to have a very strong criteria, 8 to 10 reputable sources where they're publishing articles about you. Okay, let's take another question. Am I able to file both the EB-1A and I-140 concurrently? So this relates to the answer that I was giving previously. It depends on your country of birth. If you look at the visa bulletin chart and you see if you're in the US with a non-immigrant status and you look at the dates for filing, you look at the first employment category. And if you're not born in a country where there is a long wait, like India, China, Mexico, or Philippines, if there is a C as current, then yes, you're able to file concurrently. Okay, let's take another question. Okay, how can someone begin building a strong profile for the EB-1A or EB-2 NIW in the biomedical or health informatics fields? For both, I think for both, it is very important to show how making the tie and the connection between your work and the need of your work in the US. Thankfully, biomedical health informatics, it's a huge shortage of professionals in the US with these credentials and also a huge need. So I would definitely look at the research, look what areas have the highest need, look how your work is directly contributing to this type of need, right? And start then making the argument of how your work directly impacts this type of need and shortage, right? Focus on publications, how your work is being cited by other professionals. Where is your work being cited by other professionals? This is why it's so important to have a Google Scholar page and also to track the places and the areas where your work is actually being quoted. And like I said before, networking is essential for either of these categories because you want professionals in the field who are experts in the field, who are trusted in the field, to write very strong recommendation letters for you. Okay, let's move to the next one. To claim critical role, well, what else we need along with the recommendation letters and how many will USCIS really expect? So I think this is these are two questions. The critical role is a different category. Is the category that requires you to be in a critical role at a reputable organization. Critical role is usually seen as someone that has decision-making power, someone whose role is critical to the organization. If you're a manager, if you're someone that's handling a large account, also if the organization is reputable, if it's a large organization, if it's been operating for several years, that will meet the critical role criteria. Now, in terms of the recommendation letters, usually attorneys use the recommendation letters to prove that you have contributed to the field. And for these ones, I recommend 5 to 6 very strong letters rather than 10 or 15, right? Keep in mind, the officer adjudicating your petition, like how will an officer feel like when they're reading 20, 30 recommendation letters, right? That are very broad. So it is better to have 5 to 6 very strong letters. From my experience, I see that officers give a lot more weight to independent recommenders. So for people that have not worked with you directly, people who have not been coworkers, direct managers, supervisors, just industry experts, right? And also to have a diverse group of people like professors or CEOs of startups or researchers or people in universities. So try to have a diverse pool of recommenders that are familiar with your work. And another recommendation that I give is to try to make their job as easy as possible. Offer to draft the letter, right? Like offer to provide them with everything they need so that they just have to look at it, provide feedback, and approve. Okay, let's take a few more questions. We have a last question right here. I'm a screenwriter from Somalia and I'm still building my portfolio without sold scripts yet. Can I qualify for the O-1 or EB-1 based on the creative work and future potential? So when you're applying for an O-1, you have to keep in mind that officers look at your past contributions, your current contributions, and how likely you are to contribute in the future. So they don't really just take into account future potential. It's more about the past and the present. So I will say keep working on building your portfolio and your profile. Become a trusted expert, especially with screenwriters and people in the media. It is very essential to get as much online presence and recognition as possible, so that your name starts being well known. Also submit your work for award considerations and start building that portfolio of awards. Awesome. So thank you everyone for joining us today and for asking questions. And we have our website here. If you have any other questions, we also posted the link on the chat. If anyone wants to schedule a consultation with one of our attorneys, we're more than happy to provide you with guidance. Like I said, all of the attorneys here are very passionate about helping foreign professionals realize their dreams in the US. We have experience handling hundreds, if not thousands, of this type of applications. So we know what officers are looking for. We know what holds credibility, what holds weight, how to be creative in terms of packaging your petition. We also have a program where we offer mentorship for people who have a strong foundation and are looking to eventually apply for either an EB-1 or O-1, but they're not there yet. So they need more guidance, more tailored guidance on what actions they need to take to solidify that profile. So when they file for the application, they have a stronger petition. But thank you everyone for joining, and I hope everyone has a lovely day today.